Good afternoon. My name is Kim Stanger. I'm a partner with the law firm of Holland & Hart. I'm the head of our health law group, and this is the next in our series of monthly webinars that we do talking about different health law issues. Today we're going to be talking about federal and state fraud and abuse laws. This is the second in a series of webinars that we're doing over the next month or two dealing with fraud and abuse issues. Last week, my partner Eric Maxfield talked about the Eliminating Kickbacks and Recovery Act, or ACCRA, a new statute. I understand that there may have been some technical difficulties and it may not have gotten reported, so I'm going to talk briefly about that today. Mainly, I'm just going to cover the other fraud and abuse laws. Then, over the rest of the series, I'm going to be talking about how you actually apply those. First, on July 18th, we'll be talking about waiving co-pays, offering free or discounted items or services to beneficiaries and things like that, really focusing on the inducements that may be given to beneficiaries or patients. Then on August 8th, we'll be talking about the relationships with physicians, talking about compensation arrangements, professional courtesies, or other type of arrangements with providers. So if you'd like to sign up for any of those and you haven't gotten the link for that, just go ahead and contact Laura and we can make sure that you get signed up for those items. Laura should have sent you a link with a bunch of written materials that we provided to you. If you did not get those written materials, by all means, check with Laura and she can make sure that you get those. With that said, let's talk about fraud and abuse. No surprise here, the government is very concerned about fraud and abuse because the Medicare Trust Fund is getting depleted faster than it looks like it should or will need to be in order to continue to provide care for all we old people in our old days. Because of that, the government is very aggressive in going after entities for improper payments. In the end of 2018, the report was that they recovered $2.5 billion for healthcare fraud or false claims just in 2018. Interestingly, for every dollar spent in their enforcement efforts, the government recovers $4. What does that mean? That means the government has every incentive to aggressively pursue these fraud and abuse statutes because that's more money back into their pocket. You just have to look at some of the settlements over the last few years to get an idea of the tens of millions of dollars that can cost an organization if you fail to comply with the rules. To make matters worse, the government recently increased the penalties that are applied in the fraud and abuse situations. In most of them, they've doubled or more the amount of the penalties. In addition, they've imposed cost of living adjustments, so those will continue to go up each year. These are the most current penalties and fines that are associated with the violations of the things that we'll talk about today. The laws that we're going to discuss, first, the False Claims Act, then we'll talk about the AntiKickback Statute, ACCRA, the Federal Stark Law, the Civil Monetary Penalties Law, give you a highlight of the new Travel Act theory that's been going around a little bit lately, and then we'll talk a little bit about some of the state laws. First, the False Claims Act. This is really the government's main weapon in going after entities to recover overpayments or improper payments. The False Claims Act has been around since the Civil War. It says you cannot knowingly submit a false claim for payment to the federal government. And as part of the Affordable Care Act, the government added a report and repay obligation. Under this new rule, this new statute, it says that an entity must report and repay an overpayment within the later of 60 days after the overpayment was identified or the date the corresponding cost report is due. So you have an affirmative obligation to narc on yourself. If you received payment improperly, then you've got to affirmatively report and repay it. If you don't, then that turns into a False Claims Act penalty violation, and you can be hit up with the penalties that are associated with False Claims Act violations, including, at the very least, you've got to do your repayment plus interest. In addition, you can get hit up with civil monetary penalties of $11,000 to $22,000 approximately. It's adjusted based on cost of living, but that's penalty is per claim. So it's not just per mistake that you made, but for every time you submitted a false claim to the government, they can get that money back plus impose this penalties of $11,000 to $22,000 per claim. So for example, let's say that you've been submitting the wrong CPT code, perhaps innocently, but you subsequently discover it. Well, you can get hit up for this penalty for each claim that you submitted under that wrong CPT code. So those penalties can add up extremely fast. In addition, to add insult to injury, they can also recover treble damages under the Civil Monetary Penalties Law, and you can be excluded from Medicare or Medicaid. Now, you not only have to worry about the government coming after you in these False Claims Act situations, but the False Claims Act also authorized what are called qui tam lawsuits. Essentially, qui tam lawsuits authorize private individuals to act as bounty hunters. They can sue you on behalf of the government for False Claims Act violations, and then they can recover a percentage of any settlement or penalties that are assessed against you. So now, ex-employees, disgruntled employees, competitors, they have an incentive to assert these claims against you because they can become bounty hunters. They can recover money for any of these claims that come out against you. Now, none of you guys are all good people, right? You all have integrity. None of you would knowingly submit a false claim to the government, but it can arise in situations where you didn't necessarily expect or intend it, including if you submit claims for services that were not provided or different than claimed. Even if you did so ignorantly, if you subsequently learn about it and fail to repay it, then that can turn into a false claim. It can arise in situations where you fail to comply with the quality of care, because government payers, they only pay for quality care. They don't pay for worthless care. And therefore, when you submit that claim, you're impliedly certifying that the information or the care that was provided satisfied the relevant standards. And if you fail to do that, then you submitted a false claim. In addition, the one that we're really dealing with mostly today is False Claims Act situations can arise when you fail to comply with the conditions of payment or other relevant conditions associated with that payment, including you fail to comply with relevant fraud and abuse laws. The theory here is that when you're submitting that claim to the government, you are making implied certification that you have satisfied all the regulatory requirements in order to submit that to the government. And if you fail to comply with these fraud and abuse laws, then you have submitted a false claim to the government. That was affirmed in the Supreme Court's Escobar case. When the government wants to look and see whether or not you really have engaged in false claims because you failed to comply with one of these regulatory conditions, they'll look at the materiality of that condition. If that compliance with that regulation was a material condition for the payment for that service, then you can be liable for a false claim if you fail to report and repay that back to the government. All right, that is the False Claims Act. Again, that's kind of the government's go-to weapon when it comes to this stuff. But there are other things you have to be concerned about, including the federal Anti-Kickback Statute. The Anti-Kickback Statute says that you cannot knowingly and willfully offer, pay, solicit, or receive remuneration to induce referrals for items or services covered by a government program, government health care program, including Medicare and Medicaid, unless the transaction is structured to fit within a regulatory safe harbor. Now, that's the standard. So if you're doing any kind of deals with referral sources, you're going to want to consider the Anti-Kickback Statute. Now, under that Anti-Kickback Statute, note that you cannot knowingly and willfully offer. It's an intent-based statute. You have to have improper intent. But the government doesn't have to prove very much to establish improper intent. They apply what's called the one-purpose test, meaning that the Anti-Kickback Statute applies if one purpose of this remuneration that you're paying is to induce or reward referrals, even though you've got 99 legitimate reasons. If one reason, one small little piece of that, is because you're hoping to get more referrals or you want to induce or reward more referrals, then if one piece of that, then that's a violation of the Anti-Kickback Statute unless you've structured the deal to fit within a regulatory safe harbor. That's pretty difficult to disprove. If you've got a referral source that's sending you a lot of stuff, it's really hard to convince the government that, I had no idea when I gave them these gifts or those baskets that this had anything. That was not one purpose of why I was doing it. That's difficult to disprove. In addition, note that in the wake of the Affordable Care Act, ignorance of the law is no excuse. It doesn't matter if you didn't know that it was a violation or that you were violating the law. Ignorance of the law is no excuse. Well, what happens if you violate the Anti-Kickback Statute? Well, that False Claims Act, that is a civil statute, right? You just have to pay back money. But under the Anti-Kickback Statute, you can go to jail. Not only can you go to jail, but you can go to jail for longer because they recently increased the penalty. So the penalty for an Anti-Kickback Statute violation is up to 10 years in prison. You also have to pay up to a $100,000 criminal fine. You can get hit up with an additional $100,000 civil monetary penalty, treble damages, and automatic exclusion from Medicare or Medicaid. Now, that's bad enough, but what's really bad is under the Affordable Care Act, they made an anti-kickback violation an automatic violation of the False Claims Act. That means that if you've got an anti-kickback violation, you've also got a False Claims Act violation, which means that you can get hit up with all of those other penalties that we talked about earlier. In addition, because this False Claims Act is a civil statute, the penalties are civil in nature, that means it's a lower standard of proof. For the government to prevail on an anti-kickback violation case under the statute, they've got to establish proof beyond a reasonable doubt, right? That's the criminal standard. But in the False Claims Act, they just have to establish preponderance of the evidence. So it's easier for the government to go after you now for an anti-kickback violation, but at least under the False Claims Act. In addition, because the False Claims Act penalties apply, you can also get hit up with a key tam lawsuit based on what would appear to be anti-kickback violations. The government has said that if you discover an anti-kickback violation and you go to self-report to the OIG, the Office of Inspector General, which is the police for these things, then they said that the minimum amount that they will settle for a self-reported violation of the anti-kickback statute is $50,000. So you want to stay far and away from any anti-kickback violations. When it comes to the anti-kickback statute, remember this. Anytime you want to give or receive anything to induce or reward referrals for federal health care programs, or you do any deal with a referral source for federal health care program business, you've got to be concerned about the federal anti-kickback statute. Now, note that the anti-kickback statute applies to any time you offer remuneration to potential referral sources for federal program business. Well, what is remuneration? Remuneration is very broad. It's anything of value. It could be money. It could be free or discounted items or services. For example, maybe you're offering this referral source some kind of a gift or some kind of a perk or practice support or free space or free use of equipment, free meals, free insurance subsidies, trips, CME, whatever. As long as it's anything of value, that could constitute remuneration. It could be overpayments or underpayments, not charging them fair market value. Maybe you're paying them for services that they really didn't provide. Well, you're overpaying them, and that could be a violation of the anti-kickback statute. Payments for items or services that are not necessary. You really don't need this service, but you want to, this guy's a good referral source. So you want to come up with a way to float him some money, so you're going to go ahead and pay them even though you really don't need the services. Could be professional courtesies, waivers of copays or deductibles, low-interest loans or subsidies, business opportunities that are not commercially reasonable. Anything else of value could potentially trigger the anti-kickback statute. Case in point, U.S. v. Anderson. This was back in 2001, but it's an oldie but goodie, and it demonstrates kind of the concerns here. In this particular situation, a clinic or a healthcare provider paid two physicians who were substantial referral sources. They were geriatric physicians. They had a pretty good book of business. This clinic wanted to bring them in-house so that they could allegedly secure their referrals. They hired these guys as consultants that paid them about $75,000 a year to co-direct their geriatric department. But when the government came in there and looked at this, they looked at the services these physicians were providing, and at least according to the government, they weren't doing anything in exchange for getting that money. The government concluded, well, obviously then they were getting paid in order to induce referrals, not for any legitimate services they were actually providing. As a consequence, the two physicians went to jail, had to pay fines, not only the physicians though, but also the CEO, and the CEO was convicted. The CFO was originally he was originally acquitted, but that was subsequently reversed. I guess the only good news is the clinic attorney got off. But even then, that's a little bit scary for me as an attorney that the government's going to look behind these deals to look at the advice that we're giving and the like. The bottom line there is nobody's safe. If you're involved in these types of deals, you've got to be really, really careful. This also highlights that the government is not afraid to go after individuals, not just the organization, but the individuals who are involved in these transactions. Since 2015, 2016, the Department of Justice has really made it a focus of trying to enforce the fraud and abuse laws, not only by going after the facility, by the organization, but also targeting the decision makers who decided to engage in those things, because they felt like that's the only way that we can really stop this. If the organization just has to pay back the money, that may not be big enough deterrent, and therefore we're going to go after individuals, the people in the C-suite, or others who are actually involved in this. So they're targeting individuals on these fraud and abuse laws. Well, because the anti-kickback statute is so broad, the government has identified certain safe harbors, that if you structure your financial relationship to fit within these safe harbors, you're safe. That's what a safe harbor is, right? Doesn't matter if you've got improper intent, if you structure the deal to fit within the safe harbor. But in order to get that safety, you've got to satisfy all the requirements of that safe harbor. And each of these safe harbors have different requirements that you've got to meet. So when you structure your deal, you're going to want to crack the books, look at the safe harbors, and make sure that you can satisfy all the conditions that are associated with that safe harbor. For example, there's safe harbors associated with employment arrangements. Actually, that one's pretty broad. As long as you're doing compensation arrangements with employees, you've got a lot of latitude. Not so much if you're doing contracts with independent contractors. There's certain conditions that you have to satisfy. There's safe harbors for leases of space or equipment, investments in the group practice, the sale of practice, the recruitment arrangements, waivers of co-pays and deductibles, free transportation programs, OB malpractice insurance subsidies, the provision of free IT support or items or services, and so forth. The key here is that there are numerous safe harbors, but you've got to satisfy the specific requirements in order to get the benefit of those safe harbors. Now, the government, under the anti-kickback statute, allows you to submit a proposed transaction to the OIG to review and get an advisory opinion. So if you want to know whether this deal is bad, whether the government would come after you, you can submit this advisory opinion to the government. They'll take a look at it and tell you that, yeah, we think there's a problem and we'll come after you, or no, under these particular circumstances, we're not going to come after you. Now, those advisory opinions are published on the OIG's website. The advisory opinion themselves are only binding on the parties to that opinion. So others who just go on there and look at them, they can't generally rely on those. But if you can structure your deal to fit within one of the advisory opinions, you're probably going to be safe. If the government approved it in the past, they're probably going to approve it in your situation too. So you're probably safe, but not absolutely safe. The bottom line there is if you want to do a deal, you can't fit squarely within a safe harbor, you may want to go onto the government's website and look for a favorable advisory opinion to see whether or not you can satisfy those requirements, and that might provide you with a degree of comfort in organizing your arrangement. All right. Now, that brings us to the Eliminating Kickbacks and Recovery Act, or ACCRA. This actually came out just this past year. It's part of, get ready for this, you ready for this? The Substance Use Disorder Prevention that Promotes Opioid Recovery and Treatment for Patients and Communities Act. That goes to show that the government will go to great lengths to come up with a cool acronym like the SUPPORT Act. The SUPPORT Act was a response to the opioid epidemic. So the government came up with, I think there were about 120 different provisions within the SUPPORT Act, different bills that all got kind of mashed in there. At the last minute, somebody stuck in the ACCRA provisions. Under ACCRA, it says that you cannot solicit, receive, pay, or offer any remuneration in return for referring a patient to a laboratory, recovery homes, or clinical treatment facility unless the arrangement fits within a regulatory safe harbor. So it's kind of patterned after the anti-kickback statute, right? Couple of points, though. Well, we'll get to those points in a minute. What happens if you violate the ACCRA? Well, this is a criminal statute. This is another one where you can go to jail, only this time you have to pay $200,000 in fines. In addition, you can get up to jail for up to 10 years in prison. Now, a couple of comments on this, comparing it to the federal anti-kickback statute, right? You can't offer remuneration. The statute doesn't define remuneration, but I'm assuming that they would be consistent with the anti-kickback statute, which is anything of value. Now, under the anti-kickback statute, it applied to anybody. Referrals for any federal program, any services that are payable by federal healthcare programs. This particular statute, though, it only applies to referrals to a patient to a laboratory, recovery home, or clinical treatment facility. So in some ways, it's narrower than the anti-kickback statute. In other ways, though, it's much broader. It applies to anyone who's involved in the kickbacks, like the anti-kickback statute. It's not just providers, but C-suite people or anybody else who's involved in that, the kickback situation or the financial arrangement. They are potentially at risk. It only applies to arrangements with laboratories, recovery homes, or clinical treatment facilities. Most of you probably aren't dealing with or aren't representing recovery homes or clinical treatment facilities, but almost all of you probably have some kind of affiliation with a laboratory. Now, laboratory is very broad. It wasn't limited to just laboratories that were involved in opioid issues, not just toxicology labs. It applies to all clinical labs. Now, that's pretty bad, but what's worse is it applies to arrangements that would otherwise be protected by the anti-kickback statute, because under the anti-kickback statute, remember, it only applies to referrals for items or services payable by government healthcare programs. But ACCRA is not limited to government programs. It applies to any services that are provided by these labs, even if they're paid by private healthcare payers. So it applies to not only federal programs, but even private payers. So therefore, it's much, much broader. The key there is what may have been okay under the anti-kickback statute may be prohibited under ACCRA. So just because you set up your compensation arrangements with your employees under the anti-kickback statute doesn't mean you're going to be safe under ACCRA. For example, under the anti-kickback statute, it's generally okay. You can pay employees commissions based on referrals for items or services. Now, that's employees, not independent contractors. But under ACCRA, you can't, at least based on the statute. It doesn't appear that you can. You can't pay employees for that. So if you've got a compensation arrangement whereby employees are compensated based on the volume or value of their referrals for labs, then that's probably going to be an ACCRA violation. You need to go back and look at your compensation arrangements with your employees as well as other entities to make sure that you're still in compliance with ACCRA. We haven't got the regulations on these yet. We've just got the statute. Until we get those regulations, I like this sign, beware of, well, just beware, because we really don't know how the government's going to enforce that or what they're going to do until we get those regulations. Until then, you better be careful. Now, ACCRA, like the anti-kickback statute, does have safe harbors, but these safe harbors are much more narrow than the safe harbors under the anti-kickback statute. And just because you comply with an anti-kickback statute safe harbor doesn't mean you're going to be protected under ACCRA. ACCRA does have a safe harbor for compensation arrangements that satisfies the anti-kickback statute personal services and management safe harbor, but that safe harbor prevents you from compensating your contractors or employees based on the volume or value of referrals. And so the net effect of this is, as I mentioned earlier, under ACCRA, you generally can't have compensation arrangements with your employees or contractors that's going to vary with the volume or value of referrals for laboratory services. Again, big issue. Make sure you're taking a look at those. All right, let's talk next about the Ethics and Patient Referrals Act, or STARK. To help you understand STARK, it's helpful to know how STARK came about. Back in the late 1980s, the government had switched to and really cut back on the reimbursement it was paying to physicians, and therefore physicians were looking for alternative sources for payment. Suddenly, the government started getting a lot more claims for things like labs and imaging services, and they started looking into it. Well, why are we getting so many more claims for this stuff? They concluded that the reason was, well, physicians were trying to supplement their income, so they were opening or investing in their own labs or imaging services, and then they were sending their patients over to get these additional services. And the government was concerned that they're doing it not necessarily for the benefit of the patient, but because these physicians were getting more money. So Representative Pete Stark stepped in and said, well, we can address that. So they came up with the Stark Law. Stark says that if a physician or their family member has a financial relationship with an entity, the physician may not refer patients to that entity for certain designated health services, or DHS. And if they do make an improper referral, that entity may not bill Medicare or Medicaid for such designated health services unless they've structured the deal to fit within a regulatory exception. Couple of points here. Note that Stark doesn't prohibit the financial relationship between the physician or their family member and this other entity. Sure, physician, you can invest all you want, but you just can't make referrals over to that other entity unless you've structured the deal to fit within a regulatory safe harbor. I spend a good deal of my life structuring deals to fit within Stark regulatory safe harbors. Well, what happens if you violate Stark? Well, you can get hit up with penalties. Again, this is a civil statute, not a criminal statute. But at the very least, you can't get paid for services that were provided per an improper referral. So if you did get paid for an improper referral, you have to repay the payments improperly received within 60 days, both under the Stark Act and under the Affordable Care Act provisions under the False Claims Act. If you fail to do that, well, under Stark, you can get hit up with civil penalties. As recently adjusted, that's up to about $25,000 per claim submitted. If the physicians are trying to do some kind of a circumvention scheme around Stark, they can get hit up with penalties of $165,000 per scheme. In addition, if you have a Stark Law violation, that's also going to be a violation of the False Claims Act, so you can get hit up with those additional penalties. On top of that, a lot of your Stark Act violations may also violate the Anti-Kickback Statute, so you've got to be concerned about the criminal penalties that may also rain down upon your head. Case in point about the potential ramifications, this actually came out a few years ago, back in 2015, where Toomey Healthcare had to pay $237 million arising out of allegedly improper compensation arrangements with referring physicians. This is a good example of how the penalties can compound. At trial, it was determined that that the hospital was paid about $40,000 for improper referrals. Under Stark, under the False Claims Act, they can get hit up with treble damages for those penalties. So that brought the penalties up to $117,000, or roughly $118 million. In addition, remember, under the False Claims Act, they can get hit up with civil monetary penalties. At the time, the penalty was $5,500 per claim. So you have 21,730 false claims that were submitted, because that's the number of claims that they submitted in violation of Stark. That gets you up to another $120 million. The final take on it was the judgment actually came in at $237 million. They ultimately settled for $72 million, but that's going to be a hit to your bottom line. This was brought initially as a qui tam lawsuit, and therefore the relator, the person who sued on behalf of the government, received $18 million out of that settlement. Bottom line there is you got to take Stark very seriously. So any financial relationship or item of value between a physician or their family member and an entity providing DHS has to be reviewed carefully to make sure that you've complied with Stark. A couple of points on this. Stark applies to referrals by a physician to entities with which the physician or their family member has a financial relationship. So unlike the Anti-Kickback Statute, or ACCRA, which applies to anybody, Stark only applies to referrals by physicians, which are MDs, DOs, oral surgeons, dentists, podiatrists, optometrists, and chiropractors. It wouldn't apply to referrals from, for example, advanced practice providers, unless, of course, they are doing it at the insistence of a physician. In addition, it also applies if they're to the physician's referrals if the physician's family member has an investment interest in or a financial relationship with that other entity. Note that Stark applies to referrals by the physician to entities which the physician or the family member has a financial relationship. That financial relationship can be either a direct relationship or an indirect relationship. For example, you may have a contract with another entity. That entity is in turn owned by a second entity, and that entity is owned by a third entity, and the physician's family member has an ownership interest in that third entity. Well, that creates an indirect financial relationship, and it would have to be analyzed for Stark compliance. Note that Stark applies if there's a financial relationship, which is construed very broadly. It could be either an ownership or investment interest in the other entity, where the physician has stocks, bonds, a partnership arrangement, membership shares, or secured loans, etc. Or it could also apply to compensation arrangements. And that's very broad. It could be an employment contract, a professional services agreement, contract for services, lease, any kind of payments, gifts, free or discounted items, and virtually any other exchange of remuneration. Anything else of value could be a compensation arrangement. Now, unlike the Anti-Kickback Statute that applies to referrals for any item or services payable by federal health care programs, Stark only applies to referrals for certain designated health services that are payable by Medicare or Medicaid. So it's narrower than the Anti-Kickback Statute. Those designated health services are those that are listed up there. For you who are with hospitals, most importantly, it applies to referrals for inpatient or outpatient hospital services, outpatient prescription drugs, clinical labs, physical, occupational or speech therapy, home health services, radiology and certain imaging services, radiation therapy and supplies, DME, and certain other items. The government has identified the CPT codes, or most CPT codes that are covered by Stark. So if you want to know whether or not a particular CPT code implicates or constitutes designated health services, you can go to the government's website there, and it will list the CPT codes that constitute designated health services. Now, you have to be a bit careful because that section, that website is not comprehensive. It identifies most of the CPT codes that constitute designated health services, but not all of them. So if you go there and you find your CPT code listed there, you know it's DHS. If it's not listed there, it may not be. It doesn't necessarily mean that it's not DHS. Now, because Stark is very broad, just like the Anti-Kickback Statute, there's a whole number of safe harbors that you'll want to comply with. Some of those safe harbors apply to both ownership and compensation arrangements. Some apply to just ownership arrangements. Some apply to just compensation arrangements. So you have to analyze what type of compensation arrangement or what kind of financial relationship you have, and then look for an appropriate safe harbor that applies to that relationship. The most important for physicians operating out of their group practice are the group practice exceptions that appear under Stark. That basically allows group practices to share practice income in ways that other entities can't. There's a safe harbor for services that are rendered by another physician in the same group practice. There's also the in-office ancillary services exception that allows referrals within the group for these in-office ancillary services. But you have to satisfy certain requirements. You have to truly qualify as a group practice under Stark, and there's a whole bunch of requirements for group practice compensation arrangements or group practice requirements, including the way that you structure your compensation arrangement within the group. So to qualify as a group practice, you got to meet those qualifications. In addition, you also have to meet the requirements for a particular safe harbor. Other exceptions apply to ownership, or apply only to ownership or investment interests. Most importantly here, if you are located in a rural area, then there's a very broad exception that applies to physicians' ownership interest in an entity in a rural area. There's the whole hospital exception. This is the exception that allowed physicians to have an ownership interest in like a surgical hospital or a whole hospital. They limited that. The Affordable Care Act limited the applications or their ability to expand those ownership interests in those types of facilities, so that but the prior arrangements were grandfathered in. So the bottom line is you need to check that. All right, there are also lots of exceptions that apply to compensation arrangements. This is probably where I spend most of my time, dealing with different types of compensation arrangements between physicians and entities with which the physician has a financial relationship. There are exceptions for employment arrangements, for personal services contracts, for space or equipment rentals, for timeshare arrangements, for physician or mid-level recruitment. If you want to offer a physician retention bonus, there's a safe harbor for that. There's safe harbors for fair market value, non-monetary compensation up to $300, certain medical staff incidental benefits, compliance training, again, for some information systems, for professional courtesies, and so forth. The bottom line there is, if you've got a financial relationship with a referring physician, and that physician is going to refer designated health services payable by Medicare and Medicaid, you need to structure your deal to fit within one of these regulatory safe harbors. And you're going to have to crack the books, look at the regulatory safe harbor, and make sure that you can satisfy all of those requirements. Now, remember, the Anti-Kickback Statute was an intent-based statute. You had to have improper intent, although the test for improper intent is pretty low. It's that one-purpose test. In contrast, Stark is what we call a strict liability statute. It doesn't matter whether you had good, bad, or indifferent intent. The only question is whether or not your arrangement violates the statute or fits within one of these regulatory safe harbors. It doesn't matter whether you had good, bad, or indifferent intent. So it's really important that you structure your arrangement to fit within a regulatory safe harbor. Now, just like the Anti-Kickback Statute, the government does publish advisory opinions. So if you want to do a deal, you don't know whether it's going to fit within the safe harbor, or maybe it doesn't fit within the safe harbor, and you want to know whether the government's going to come after you, you can submit this advisory opinion. They are published on the CMS's website. There's not as many as there were for the Anti-Kickback Statute, but you could get those advisory opinions. If you want to do a deal, you can either submit it yourself, or you could get the advisory opinion and see how the government's treated those other relationships. If you structure the deal to fit within an approved advisory opinion, no guarantee that you're going to be safe, but you're probably going to be relatively safe. All right, that is Stark. Let's talk about the Civil Monetary Penalties Law. The Civil Monetary Penalties Law is kind of a hodgepodge of a whole bunch of different laws that are all kind of thrown together to identify certain misconduct and impose penalties for that misconduct. It incorporates other provisions, like it's the one that creates the civil monetary penalties associated with, for example, violations of the Anti-Kickback Statute, Stark, MTELA, or the like. I'm going to just focus today on three aspects of the Civil Monetary Penalties Law. The first is before we get there, on the Civil Monetary Penalties Law, the penalties for those violations vary depending upon the conduct, but anywhere from penalties of $5,000 up to $100,000, at least under the current amounts. You can get hit up with treble damages. You can get denial of payment. You'll have to repay amounts improperly paid, and you could be excluded from the government programs. Remember, there's a lot of overlap through these statutes. So violations of the False Claims Act, Anti-Kickback Statute, START, or ACCRA, they could also trigger violations under the Civil Monetary Penalties Law or be subject to penalties under the Civil Monetary Penalties Law. So let's talk about the three that I wanted to discuss today. The first is inducements to government program beneficiaries. You generally cannot offer or transfer remuneration to a federal program beneficiary, like a Medicare or Medicaid patient, if you know or should know that remuneration is likely to influence the beneficiaries to order or receive items or services payable by federal or state programs for a particular provider or from a particular provider. So they don't want you out there offering these inducements to get Medicare or Medicaid patients to come to you or to somebody else for those services, because that's just going to drive up the cost of services. And again, you may be making those inducements not necessarily because it's in the patient's best interest, but because you want some kind of an award. Well, what's the penalty on that? Well, they recently doubled that up to $20,000 for each item or service. You can get help with treble damages, so you have to repay amounts improperly paid, and you can be excluded from Medicare or Medicaid. Now, if you've got a violation of this provision of the Civil Monetary Penalties Law, it's also likely a violation of the Anti-Kickback Statute, because the Anti-Kickback Statute applies to inducements to patients also. Now, it applies to inducements to anybody who may make a referral, and patients can refer themselves. So you need to be concerned about the CMPL. Now, it's very broad, just like the Anti-Kickback Statute. It applies anytime you offer remuneration, and remuneration is basically anything of value. The definition specifically says that it applies to items or services for free or less than fair market value unless you satisfy certain conditions, and it includes expressly under the statute waiver of co-pays and deductibles. unless you satisfy certain conditions. So if you have a practice of doing insurance-only billing, or you want to waive all or part of a patient's copay or deductible, well, that is a likely violation of the civil monetary penalties law unless you satisfy certain conditions. Now, the government has said that they will not prosecute a provider based on if all they're doing is providing an item or service that is of relatively low value. And they define low value as each item or service is less than $15 and the aggregate amount that you're offering that particular patient in a year is up to $75 per patient per year. So you can give a gift to a patient of no more than $15 each, and you can't give the total number of those gifts, all of those gifts, the aggregate value can't exceed $75 per patient per year. Now, the civil monetary penalties law, this particular provision, the patient inducement provision, does contain some safe harbors that are contained in the definition of remuneration. Remuneration is defined to exclude waivers or copays. If you're going to waive copays or discount copays or deductibles, if it's based on financial need or after failed collection efforts, if certain other conditions are met. So you can't just do it as kind of a marketing gimmick, but if there is demonstrated financial need, it's not advertised in advance, or you've got failed collection efforts, then they will allow you to go ahead and waive that copay or deductible, and that's not a violation of the civil monetary penalties law. There's also an exception for items or services if the financial need and certain other conditions are met. So you're going to provide, free or discounted items or services because of financial need. We'll talk more about that next week. Incentives to promote delivery of preventative care if certain conditions are met. That's kind of not necessarily a catch-all, but it identifies certain types of preventative services that actually benefit Medicare if you get these preventative services because it avoids further costs down the road, and so they give you an exception for that. Payments meeting an anti-kickback safe harbor are already incorporated into the CMPL, so as long as you can satisfy the AKS safe harbor, you're okay into the CMPL. And they've got a catch-all for any other remuneration that promotes access to care and poses a low risk of harm to patients in federal health care programs. That's not very well defined, but it gives you kind of this catch-all. As long as what you're doing promotes patient care and doesn't pose a risk to federal health care programs, you may be able to fit within that exception. Okay? That is the CMPL for patient inducements. Well, the CMPL also prohibits certain types of payments that a hospital or critical access hospital may make to physicians as an inducement to reduce or limit medically necessary services provided to Medicare or Medicaid beneficiaries. Now, to understand this, you have to understand the context. Again, when the government a few years ago, well, a lot of years ago now, went to the PPS system, so that hospitals now are paid based on DRGs. They're not paid based necessarily on the services. It's not fee-for-service based on what the hospital provides, but instead they get a set amount for the patient who shows up with this DRG. The government was concerned, well, now hospitals have this incentive to provide lesser care, right? Because they get a finite amount no matter how much care they provide. So the less care they can provide, theoretically, the more profit margin they make. And so the government was concerned, we don't want situations where the hospitals go out to the physicians and say, hey, we will offer you some kind of inducement if you order less services for this particular patient. That's really what this provision is designed to protect against. What are the penalties? Well, $5,000 for each individual with respect to whom the payment was made, and any other penalty allowed by law, which it could create Stark issues, it could create anti-kickback problems with this. Now, for those of you who are aware of, accountable care organizations and the like, you're thinking, well, that's what they are, right? Those are accountable care organizations because they want to share cost savings with those who are participating in the program. If you structure your arrangement to fit within certain government-approved cost-sharing arrangements, then you'll be okay. The government is working on certain safe harbors for gain-sharing arrangements, those types of things. But unless you can fit within those, then you've got to be concerned about these payments to limit services. Next part of the CMPL law that I wanted to discuss is the prohibition against contracting with excluded entities. under the civil monetary penalties law, you cannot submit a claim for an item or services that's ordered or furnished by an excluded person. If that person has been excluded from participating in Medicare or Medicaid, it's kind of like the death knell for them. They cannot now go to work or they can't submit claims to the federal government for any items or services that are ordered, with the exception of like emergency room services. In addition, it goes on beyond not only to those people who are submitting claims, but it also says that you as a healthcare entity, you can't hire or contract with an excluded entity or arrange for any excluded entity to provide items or services payable by federal healthcare programs if any of the money that comes from the federal government is going to make its way to that excluded entity through like salary or wages or things like that. That effectively prohibits you from hiring anybody who's been excluded. I guess theoretically, if you parceled out the money that comes into your organization, you might be able to siphon that off and be able to show that no federal program money was used to pay their salary, but that's really difficult to do. Bottom line is, if you are excluded, that's the death knell for your participated in healthcare really in the United States these days. So you want to make sure that you carefully watch for those exclusion issues. What are the penalties? Well, $10,000 per item or services. You also can get hit up with treble damages. You have to repay the amounts that you received in violation of this, and you can be excluded from Medicare or Medicaid. It's not only that person's excluded, but if you hire them improperly, you can be excluded for hiring them. The government is actively enforcing this also. So if they come into your organization and find out that you hired an excluded entity, even if they're not a clinical person, if they're handling billing or they're doing housekeeping or doing whatever, back office stuff, it doesn't matter. If you're contracting with them and any money from federal programs are finding their way into that guy's pocket through wages or salary or whatever, then the government will come after you and will require repayments. And they've got like a formula for calculating how much money you're going to have to repay the government. Now note that provision only applies if you knew or should have known of the exclusion. What does that mean? Well, knowledge is like it says, you knew or should have known. That could come either by actual knowledge. It could be that you're notified by HHS of the exclusion, like you submit a claim and the government sends that back to you and says, hey, this person's excluded, we're not going to pay for it. Or most importantly, if that person is listed on the government's list of excluded individuals or entities, or their LEIE data bank. So you've got an obligation to go in there and check this LEI database to determine whether or not your medical staff members, whether those people ordering services at your organization or your employees or contractors are excluded from the government. If they appear on that list, then you are deemed to have noticed that they've been excluded, and therefore you can be subject to those penalties. Well, how often do you have to check? The government said basically that they update that exclusion list monthly. You're supposed to check that list before hiring or contracting with entities. Then you should check periodically thereafter to determine their status. It used to be that the government in some of the earlier guidance said on an annual basis you should check for like your existing medical staff members and employees and the like, but we really haven't got much more guidance, more recent guidance. The more recent stuff seems to suggest that you better check it more frequently than that. Really, the only way to be really safe is to check that LEIE database on a monthly basis to make sure all your employees and medical staff members and the like aren't excluded. Just like the Anti-Kickback Statute in Stark, the Civil Monetary Penalties Law does allow for advisory opinions. So if you want to submit an advisory opinion to the OIG, you can, or you can go on there and look at the OIG's database to look at advisory opinions to see whether there's any that apply to your particular situation. All right, that is the CMPL. Let's talk now about the Travel Act. This has kind of been a hot topic for healthcare lawyers for the last year or so. Partly because there have been some convictions that have come out over the last year or two where the government has used the Travel Act to go after individuals for health care violations. The background of the Travel Act, it came out in Robert Kennedy's era. It was really designed to address racketeering. And basically what it says is, look, if a person is violating a certain state laws, including bribery and certain other state laws, mainly for our purposes it's bribery, if they're violating a state law that prohibits bribery and they're using any kind of interstate commerce or the mail, then that's a violation of the Travel Act, so that the feds now can come after you for this violation of the Travel Act based on a violation of state law, including privacy or bribery laws. What are the penalties? Well, you can get up with fines and up to 20 years in prison. Case in point, just last August, we received national headlines, at least among we healthcare attorneys. There's the district court in Texas went after Forest Park Medical Center and went after their CEO and a bunch of other people, a bunch of physicians and the like, based on alleged violations of kickback schemes. They went after them for violations of the federal anti-kickback statute, but this arrangement that they had not only involved federal payers but also private payers. Well, of course, the federal anti-kickback statute only applies to federal programs, and so they couldn't use that to go after them to the extent that the arrangement implicated private payer situations, but they used the Travel Act to go after those people for violations of the private payer arrangements. And they did it based on this Texas statute that prohibited commercial bribery. So they used that to say that, oh, these bribes were being offered in violation of this state law, and therefore under the Travel Act, we can come after you and make it a federal cause of action. The key here is that now healthcare entities that used to be able to structure their deals to fit within, as long as they didn't involve federal healthcare programs, they felt like they were pretty safe in doing kind of deals. Now, in the wake of ACCRA and in the wake of this Travel Act, you've got to be a lot more careful that even your arrangements that don't implicate federal programs may violate state law, bribery acts, or the like, and may turn into a Travel Act violation. So you've got to be aware of your state laws, which brings us to state laws. So what are some common state laws that you need to be aware of from a fraud and abuse point of view? Well, certainly all of your states or most of your states will have some kind of healthcare fraud statute. That requires a heightened level of intent, so usually you don't see those. Those are usually criminal statutes. But you might have a commercial bribery statute in some of your states. If so, that's what the government's been using to go after you under, or go after providers under this Travel Act. In the wake of some of these recent cases, there's 3 or 4 of them, you may want to go back in your particular state and see whether there's commercial bribery statute that would prohibit these types of financial relationships or these kickback arrangements, even though they don't implicate federal healthcare programs. Almost all of your states will have, or all of your states will have False Claims Act statutes. Most of those are limited to Medicaid situations, but it may be that they apply to other situations too, including private payers. You'd have to check your state. Most of your states will have anti-kickback statutes. Again, a lot of those are limited to Medicaid, government payment programs, but not all of them. For example, here in Idaho, where I happen to be today, they have a state law anti-kickback statute that's broader than the federal anti-kickback statute because it applies to private payers as well as federal programs. Some states may have their own self-referral limitations or mini Stark laws. A lot of those piggyback and incorporate the provisions under the Stark law, so you need to check with that. Most of your Medical Practices Act will have statutes that prohibit fee splitting. And so if you're engaging in a deal where you're providing some kind of kickbacks or some kind of financial benefit in exchange for these referrals, that may violate your fee splitting statute under the Medical Practices Act. You'd have to look at your own particular state for that. There may be others that are out there. Again, the key here is most of the federal stuff we've talked about before only apply to federal health care program business. But these state statutes may be broader and they may extend to private pay business. So you need to make sure that you're aware of the state laws so that you can consider those in the context of doing arrangements, even if they're not implicating federal program business. All right, that is a brief overview of federal and state fraud and abuse laws. If you want additional information, the OIG has a very helpful website dealing with all things compliance, including the access to the advisory opinions, different fraud and abuse guidance that's coming out, videos and the like. In addition, we have a lot of information on our health law blog, including a lot of articles that I've written things like that. You can access that for free just at our health law website. We do record our webinars when we remember to. Those are all on there also. We will be, as just a plug for the upcoming webinars again, in a couple of weeks I'll be taking these laws that we talked about today and applying them to different common situations that arise in your practice or at your facility. In the first one, we'll be dealing with patient situations. After that, in August, we'll be talking about relationships with other referring providers. That is it. If you have any questions, by all means, feel free to submit those using the chat feature or shoot me an email. I'd be happy to answer those questions offline as soon as I get back from the holiday. And speaking of which, I hope you all have a good holiday. I hope this has been helpful. If you have ideas or suggestions for other webinar topics that you would like us to address, by all means, feel free to reach out to me or any of my other colleagues here at Holland & Hart in our Health Law Group. Thank you very much.